Next matter, 338 Collins Avenue.
I'm going to be promoting the presentation team. Just give me a moment, sir.
Good evening, Mr. Chairman, members of the board. Michael Resnick on behalf of the applicant, Narragansett Improvement. I'm also joined this evening by my client, the principal, Dustin Everson, who will provide some testimony. But first, may I proceed with a brief presentation?
Certainly, I'll swear in your witnesses when that time comes. If you care to present initially, go right ahead.
Thank you very much, Mr. Chairman. And so I want to make the board members aware that we have reviewed the staff report in its entirety. We are aware that there's a negative recommendation here. And I also want to note that we are aware that this is a use variance, and we understand the standard, which is a high standard, which is associated with it. However, while perhaps an unorthodox request, I want to give you some background as to the context with which it's being asked, and to tell you that there have been some issues that have arisen since this application was filed with the board, which I think are germane to your consideration. And so really what this is about is a wind down of a business, Narragansett Improvement, which processes concrete and asphalt and recycles it. So instead of this material going to the landfill, it's recycled, it's located down on Allen's Ave. It's been a lessee since late 2017, early 2018. The property is owned by Cumberland Farms. So since this application was filed, we understand that Cumberland Farms has this property under contract. It's going to be sold. The buyer is unknown. It will not be released to us, so I want to head off and let the board that I don't have that type of information, but I know that the timetable is probably fairly expedient. My client is basically seeking a temporary use variance during the remainder of his tenancy. And I want to tell you that this use has been going on since 2017, 2018. The issue here is whether it's waterfront dependent or not. Historically, this area, I can tell you, I know that this board is not an administrative enforcement officer, but there's a lot of uses in this area that have absolutely no connection to the waterfront. In fact, this very property, and I don't want to digress too much, but it's been subject to a use variance for a non-water dependent use before. This very property back in, I believe, 2014 with respect to an application that has been made by Cumberland Farms. And I say that just so you understand that the backdrop of this is that the use and custom down there, especially when my client started his understanding of his use, was that it was conforming. And it was not until August of 2020 that an issue arose that was commenced by your zoning department, your zoning official, indicating that this was a non-water dependent use. So I want to tell you that as we stand here now, there has been no material brought on site within the past 6 months other than from Providence Port, which my client will explain in greater detail, which is bringing to him marine concrete. So our thought process is that we're not entirely sure that we even need to be here, because we believe there's an argument that this is a waterfront dependent use. And that is something that I don't want to spend too much time with the board on this, but will be subject to the defense of those NOVs if necessary. And the reason why we're here seeking this temporary variance is essentially to allow him to get what is on site with a condition that absolutely no more materials come on site, with an understanding that the only materials that are on site are essentially marine concrete from Providence Port, and to recycle those materials over the period of time that he has until this lease expires. You know, so I think about the standard associated with a use variance. I understand that it's high and it's a deniable beneficial use. But for this particular tenant for this period of time, this is the only use, and essentially what we're asking for is the ability to recycle these materials on site instead of sending them to the landfill over a reasonable period of time. And what I had discussed with my client was a period of 10 months to 12 months. Understanding that for all we know, this property could close much sooner than that. So we're here in a creative way. We understand that the use variance is a high standard. My client's here to testify to what the extreme hardship would be to him financially and otherwise with respect to bringing these materials off-site, storing them, processing them in a different way, or bringing them to a landfill. And, you know, to be candid, this is a operation that's based in recycling, and it's really a wind down. So, you know, that's kind of the background of this. And in order to avoid potentially protracted litigation with the city with respect to those NOVs or going down that route, we thought it prudent to attempt to seek a use variance of a temporary nature for this wind down process. And with that, I would ask, unless the board has any questions of me at this time, I would ask if Dustin Everson could be brought into the conversation so that he could discuss with you what that wind down process would be, what the timetables associated with it would be, and also the position he's in that's essentially eliminating his use for the property and the only use that is viable during this very short period of time. Thank you.
Mr. Resnick, I think what I'm going to suggest is have our council address your first issue, because to my knowledge, there is no such thing as a temporary use variance. There's either a use variance or there isn't one.
That's correct, and that's my instruction to the board. There is no legal thing as a temporary use variance. And neither does it matter who owns or who occupies the land, as you know. The variance runs to the land, not Cumberland Farms or whoever purchases it afterwards. So even assuming you could grant a temporary use variance, the next tenant would come on and still have an argument that you permitted something, and that would be used against the city in any further claims to variances. But, you know, the first hurdle is that there is no such thing. So since there is no such thing as a temporary use variance, Mr. Resnick, I would leave it to you as to whether or not you want to make a presentation to the board and have them act on it as if it were a permanent variance or not.
Well, I'd like to respond first, if I may, Mr. Chairman.
Sure, go ahead.
Yeah, well, Rhode Island general laws and the definitions contained therein define what a use variance is and what a dimensional variance is. And so your code flows from that. It has to be in absolute accord with that. And actually, the Rhode Island general laws are silent as to this. And, you know, to be candid, I have no issue modifying it to be a use variance in the way that's replicated in your code or codified in your code. But at the end of the day, I have to say, with respect to your solicitor's advice to you, it's actually a novel area of law. There's no Supreme Court decision on it. There's nothing in the general laws that states otherwise. And again, there's certainly never been a Supreme Court case that's gone up. And the way that we make law in this state is advancing novel areas where they are due. And this may be such an occasion. So that's how new law is made, and that's why the law is fluid. And that's why we have boards and judges to interpret what can sometimes be very skeletal in nature. So I would submit to the board that if your attorney is advising you that it doesn't exist and that's an automatic denial to this application, that I will modify what I stated and we can bring it back to a traditional use variance. And simply was trying to give the board some backdrop here that we're seeking this as a way to cure an issue for a short period of time and avoid litigation. Quite candidly, that's going to cost my client and the city money. So here we are trying to resolve something in an amicable way. And I don't want to be told that it doesn't exist because, in fact, the only people that get to say that is the Rhode Island Supreme Court. And they've never stated anything on the subject.
That's correct, Mr. Resnick, and this is not the Rhode Island Supreme Court. And they strictly interpret the statute and the ordinance in accordance with its plain language. And my statement is based on my multiple research into this area. And in fact, this board, a previous board from the city of Providence, granted a temporary use variance, and we have since found out that that is not legal and it's caused a lot of problems. So if you want to go make law in the Supreme Court, that's fine, but this board does not make new law. It interprets, it has no authority to do that. It's outside its jurisdiction. It can only apply the law as written. So, and actually what you've stated is you're going to modify, but in fact, the application before the board is for a use variance. It's not for a temporary use variance. So I would suggest that you proceed with that.
Excuse me, I'd like to respond to the litany of things you just stated very briefly.
This is an illegal, this is not.
Mr. Resnick, are you going to present your case?
Yeah, I would like to. I would like to bring the witness up, and it seemed to have gotten derailed.
Okay.
It's not derailed, Mr. Resnick. I'm just asking you if you want to proceed with the application you've presented to the board for a temporary, for a use variance.
That's what we're going to proceed with.
Thank you.
What we're going to proceed with. Thank you, Madam Solicitor.
Alexa, if you can bring up Mr. Everson so I can swear him in, please.
Thank you.
You're welcome.
Mr. Everson, are you available?
I am here.
Mr. Everson, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Resnick, please begin.
Mr. Everson, please state your name for the record.
My name is Dustin Everson, and I'm the president of Narragansett Improvement Company.
Okay. And could you identify the location that is the subject of this hearing?
I believe the location, as it's listed here on this the zoning board review notice of meeting, is 368, but I think it's actually 388 based on the signage that is on the road adjacent to the lot. I could be wrong, but that's what I've been told. But that is directly adjacent to a facility that is utilized by Rhode Island DOT and some other folks that are on the avenue using that for industrial use adjacent to us.
And let me ask you, Mr. Everson, in your capacity as the president of Narragansett.
Could we see his face?
I don't.
I don't know why it's not working.
And by the way, the application says 338 Allen's Avenue.
Thank you.
Whatever that's worth.
Okay, because on the letter here it says 368, that's why I'm 338 and then, okay, I see.
The lot is 368.
Oh,
Gotcha.
the rest is 3.
Thank you for that clarification. If I can continue, Mr. Chairman?
Go right ahead.
In your capacity as president for Narragansett Improvement, are you familiar at the operations for that parcel?
Yes, I am.
And can you please describe what those operations are?
Well, currently we've, like you had stated earlier, we have not taken any more material in that was not excavated or hauled from the Providence area. We're currently under contract with those folks to do some site work improvements, infrastructure improvements down there. And we have brought some more material in from that job, and we're processing that, not currently, but what we do is we bring material into that site, and we bring in a subcontractor who processes and recycles the material as to reintroduce it back into the asphalt product that we lay down in the street or parking lots, whatever it may be.
And when we ask you, can you just describe a little bit Providence, what they do, and the type of concrete that you recycle from?
Well, the Providence, as most of you know, is part of the water-dependent uses down there, and they bring in various ships, whether they be asphalt, concrete, scrap cars hauling in and out. So there's a various different berthing requirements that I guess that would come into that area. In doing so, they need some infrastructure improvements and repairs to their particular property that's there. And so that is probably be finished with that probably the end of this year, first part of the first quarter of 2022.
And also, in connection with your work with Providence, again, essentially you're recycling marine concrete, correct?
It's not necessarily marine concrete. It's bituminous concrete, which is a liquid asphalt as well as stone, sand, and aggregate. We're not actually storing any concrete at that site at all. It's actually what the term is bituminous concrete, which is essentially, like I said, it's the liquid asphalt that is mixed in with the aggregate and sand to make that product.
Okay. And Mr. Everson, is it correct that you just recently came to understand that the property that you're currently occupying is subject to a purchase and sales agreement wherein Cumberland Farms, the owner, has his property under P&S?
That is correct.
And at this juncture, you're solely, essentially, you only have a 30-day notice, so essentially a 2-month window wherein you may have to vacate the premises. Is that correct?
That is correct. We don't know any other information other than that it's potentially under a purchase and sale agreement.
And it's your, and for that period of time, is it safe to say that the only use that you can put this property to is processing and recycling the materials that you presently have on site?
That is correct. That's the only real need that I would even utilize that space for. That's why, as we recycle asphalt in our process, as you're probably all aware, it's become more and more apparent that the recycling industry, and particularly in our industry, has become more prevalent in trying to be a greener footprint and try to help the environment by not putting that type of material in the landfills and what have you like that. So in doing so, we secured that property that looked like at the time wasn't being utilized. And we figured that was a viable spot. We consulted with the property owner at that point, and entered into a lease agreement with those folks, and that's what we've been doing to try to, recycle that material, get it back into the product, to reintroduce it back to the customers, whether it be Providport, City of Providence, as it has been in the past, and that was the primary reason for that.
Right, and so as of now and as of the past 6 months, you're not taking any other material on site, is that correct?
Right, and that's the reason why, is mostly because of the fact that I don't know what's going to happen as far as the purchase and sale, how quickly that's going to transpire. So we've actually kind of minimized our operation there as far as trying to process any material, bringing it in addition to what we've already had.
Okay, and is it fair to say that removing this material from the site is a condition prior to you vacating as a tenant?
Correct.
And would it also be fair to say, based on your experience in the asphalt concrete industry, that the most environmentally responsible manner to process this material is through a recycling process?
Absolutely.
And is it in your intent to recycle all this material as opposed to send it to the landfill?
That is correct.
And could you please describe for the board members the cost that would be incurred, well, the monetary hardship that you would endure as a result of ceasing those operations and being unable to process and recycle on site, as opposed to sending it to the landfill or storing it and disposing of it in some other way?
Well, if in our area, there's very limited area to actually process material. We got not a very big parcel of land to operate on, and in doing so, to try to do this recycling, we had to secure that property. But however, if we were to take that material and try to haul it off site, we'd have to add more trucks to the road, which obviously that's not what anybody's goal is at this point. In addition to the fact that we have to pay various amounts of dumping fees to the landfill, which is quite pricey at this point, in addition to the additional logistical planning to try to figure out where this particular material would go if we didn't bring it to the landfill. So it's several tens of thousands of dollars, if not more, to try to just trucking alone, as well as dumping fees to put it in a spot where it would never get utilized again in any form.
And let me ask you, in addition to that hardship, would you say that recycling these materials is an overall benefit to the state of Rhode Island?
I would say yes, on a few different levels. One of which is it's the less liquid asphalt that we have to import from other areas of the world, because we don't make anything domestically anymore. So that would be one of the issues that we would, tackle, if you will, to minimize that. We'd also, it's just taking up more space in the landfill. We recycle it, put it back into the material, and that's the best utilization of that product, as opposed to throwing it in, the landfills, or there's other ways to do it. You can recrush it and use it for road base, but as far as getting all the ingredients back from excavated or milled surface into the street, back to where it can be utilized where it was originally put, that's the best form of utilizing that particular process and material. And
are you aware that there is presently an action that has been filed by the city of Providence relative to this issue and this use that's presently pending in the Providence Housing Court?
Are you speaking of the NOVs?
Yes.
Yes.
And are you aware that those actions have been stayed while we submitted this application for relief?
I believe so, yes.
And just very quickly, and then we will end, with respect to the use of this property, is there any way that you could sublet this or use this property for any other purpose than recycling or disposing of the materials that are presently on site?
No, I wouldn't say that would be any kind of utilization beyond what we're using it for now.
And in fact, the situation that as it presently expresses itself is that you would move very expediently, because for all you know, you could have to vacate the premises in 2 months based on your agreement with Cumberland Farms, the owner of the property, correct?
Correct, that could potentially happen.
So you have every incentive to wind down your operations in an expedient and safe manner, correct?
Correct.
That's all I have, Mr. Chairman.
I have a couple of questions, Mr. Everson, for you. How long have you been employed by Narragansett Improvement?
How long have I been employed?
Yes.
Over 25 years.
So were you working for them when this lease was negotiated?
Yes.
And is it your understanding that your company as tenants did any due diligence to find out whether their prospective use of this property to do what you're doing now was allowed?
Yes, we did, and we did not find it. It was based on what we saw on adjacent properties, in addition to the fact that, from what I understand, the zoning said that we could store material there, but it didn't indicate exactly in the same area that was, that it needed to be a water-dependent use. So at the time of our signing of this agreement, we thought that we were we're not in violation of the proposed use here.
So you thought that, not based on what the ordinance says, but just apparently what you thought?
Well, that's in addition to, what I looked at the time that I had available to me for resources, yes.
Okay, so you knew you were in a W3 zone at the time when you signed this lease? But you thought your use was allowed?
Correct.
Mr. Chairman,
Yes, Mr. Scott.
at that time, did the applicant obtain a zoning certificate? I guess I'll direct that question to Mr. Everson.
I'm sorry, can you repeat that?
Do you
So
have-
at that time that you just spoke of, when this transaction started, did you obtain a zoning certificate?
We did not.
Thank you.
Mr. Everson, also it's my understanding then that when maybe one of the notices of violation were issued, it was suggested that you go for staff level development plan review because materials processing might be allowed if it was a water dependent use. And my understanding is nothing was done to present anything to staff level development plan review committee. Do you know why that didn't happen?
I don't know why that did not happen. I was not I didn't realize that we were actually issued NOVs until much later than the actual NOVs were, I guess, issued to the owner. I think it was a couple months after that. And that's when we got notified ourselves, other than the fact that, somebody told us from the building inspector's office that we had to cease operate.
Okay. Mr. Wolf?
Yes, thanks. By the way, I wasn't checking the weather. I was doing some research related to the case on my phone here, just for a sec. Mr. Everson, is it your testimony that your company is the only company in the Metro Providence area that recycles concrete?
I'm not sure if that's the case or not.
Well, based on a little research I just did, it's not the case. There's EnviroSafe Disposal in Riverside, there's Shredfast in Johnston. I don't know if they do exactly what you do, but I guess my point is, you're implying that if we don't grant this variance, that all of the concrete that you have on site is going to go to the landfill, and that Provport may be using direct passage to the landfill for additional concrete it has that it needs to get rid of. But I think that's not necessarily borne out by the facts, because there are other options for Provport if, for whatever reason, you folks were no longer in the business of recycling concrete. Any?
I don't know if that's actually the case. Those particular companies, I believe, that you just named, I don't believe they're in the business of recycling bituminous concrete.
Well, because I couldn't tell you that, but I just think my hunch is that that you're not the only show in town when it comes to recycling concrete. And
No, there's other places that do it, I'm sure. There's other people in this industry that do the same.
So I don't
exact
think it
thing
would
we
be
do.
an environmental disaster, as I thought you were implying, if we didn't grant this variance. That's what I'm trying to get
I'm not
to.
saying it's being, no, I'm not saying it's an environmental disaster by any means.
Or even
It's
an
just the fact that
environmental
it's-
negative, even an environmental negative.
Any other questions, Mr. Everson?
I have one more.
Go ahead.
I'm just curious, we're talking about, I do agree with Mr. Wolf, there's sort of this recycle or to the landfill narrative. But I'd also be curious of the amount of concrete recycled, roughly how much of it is marine concrete from Port of Providence or Kwanzaa or other ports?
A good portion of that material, I would say at least 40 to 50% of that material there is currently from Port alone.
Anything else? Okay. Thank you, Mr. Everson. Mr. Resnick?
Thank you. One thing that I would like to bring up that I made up and had highlighted in my opening statement was that there is a history here, and I understand and respect that the zoning board members that are in place now may not have been those in 2014. But I think this is germane for two reasons. One, I think it shows that there is a history in this area of Allen's Ave of providing these use variances. And also, there seemed to be an inference, and I understand it, that inquiry into my client's due diligence and why he thought that this was appropriate in a W3. And I think something like this is germane, and I'd like to just make it part of the record that on September 6, 2014, there was an application with respect to this very property, 338 to 350 Allens Avenue. It was made by Cumberland Farms, and the relief sought was from regulations governing the use restriction whereby liquefied natural gas is not permitted to be stored in bulk in the W3 zone. The lot in question contains approximately 724,187 square feet of land water area. And this was, again, seeking relief from that water dependency. And it was granted by the board. It was granted by way of resolution number 9833. And it was recorded at book number 11,021, page 323. And so I'm certainly not suggesting that this is binding precedent, but I think that if we looked categorically at the elements without some element of discretion, we would never see use variances really granted in any circumstance whatsoever other than like a complete DEM regulatory taking. And this board has a history of providing use variances, and it seems to me that a use variance that seeks to remove concrete or recycle it rather and process it or remanufacture it and reincorporate it into our roadways probably is more beneficial than allowing liquefied natural gas containers to be put down there that have no dependency on the water. So I think it's been very loose down there. And I think that there, in fact, is a lot of selective enforcement, which isn't relative to this board. It will be relative to the NOV. But I'm just saying that there's precedence for this. And I think that the board has some discretion to do it.
I guess what I'd like to say to that is the same way I can't speak to why your clients thought they were in compliance with the zoning ordinance. I can't speak to what a zoning board did in 2014. I can't speak to the elements or the facts before them. All I can speak to is what we're dealing with today. And I'd like to focus today's hearing on what you care to present to us today.
Yeah, and I accept that, and it's certainly not binding, and I doubt that you were a board member at that time. I'm just simply saying that this area, has been subject to use variances, and for instance, the
I
state of
understand, I'm
Rhode
just trying to
Island.
say.
Mr.
I'm
Resnick?
just trying to say, let's speak about today's matter.
It was also a different ordinance. The ordinance was completely amended in effective December 24, 2014. So let's not go down a rabbit hole. I think the chair just indicated, excuse me, I think the chair just indicated that he would like to hear testimony on the...
With that, we'll conclude our presentation, and respectfully request that the board grant the relief sought, which is a use variance relative to a non-waterfront dependent use to the extent required, and we're reserving any and all rights as to whether or not the use is in fact non-dependent. Thank you.
So, clear, Mr. Resnick, you have no further testimony to present to us?
I have no further testimony. Thank you, Mr. Chairman, and thank you, members of the board.
You're welcome.
Mr. Chair, I believe Deputy Director of Planning and Development would like to speak.
Okay, in that, we're going to be reading a recommendation from Department of Planning and Development. I think it'd be appropriate for him to present to us.
Would you like to hear from him now?
Yes, please.
Good evening. Can you hear me and see me?
Yes.
Thank you. I apologize for any background noise you might be hearing. My name is Robert Azar. I am the Deputy Director of the Department of Planning and Development for the City of Providence. I have testified in front of this board in the past. I've been recognized as an expert. I believe you have my resume. Just very briefly, I've been with the department for 21 years. I'm a co-author of the current zoning ordinance and the current comprehensive plan. I would like to be recognized as an expert in comprehensive planning, land use, and zoning.
Say that you have presented to us before, and you will be accepted as an expert in comprehensive planning, zoning, and land use.
Thank you. I've just been told I have to put on my mask. I'm in a quasi-public place. I'm going to share my screen if I can do that. I have just about a dozen slides to show you. Looks like the host has disabled screen sharing, if that could be enabled.
You should be set now.
Yes, thank you. Okay, and here is a presentation that I have. I trust that you can see this.
We can.
Yes, and for the record, Mr. Azar, I did provide the board members with a copy of that map, so they have seen an individual copy, but I'm glad you have a blow-up for them.
And I believe that Alexis has a copy of my presentation that I hope can be entered into the record.
It will be included as an exhibit.
Thank you. In Rhode Island, we have a Comprehensive Planning Act, and we also have the Zoning Enabling Act. And these two...
Mr. Azar, sorry to interrupt. Mr. Chair, would you like to swear in Mr. Azar?
Thank you. Mr. Azar, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes,
Please continue. Thank you, Alexis.
thank you. We have in Rhode Island a Comprehensive Planning Enabling Act and a Zoning Enabling Act. And these two acts tell the cities and towns that they have to do comprehensive planning and they have to have a zoning ordinance. And the comprehensive plan and the zoning ordinance must be consistent with each other. What you see before you now is the future land use map of the comprehensive plan. This is step one in establishing the zoning ordinance. And I'm going to zoom in to the area in question here. You can see in the blue area to the right a little star which indicates roughly the location of the subject property. It's within a designation that the future land use map calls waterfront port. That corresponds with that blue area. And here you see that this comes right out of the comprehensive plan in chapter 11, where we talk about these land use designations. And the important point here is that this is a designation that indicates that this area is to promote the Port of Providence and related maritime, industrial, and commercial uses within the waterfront area. And specifically that the purpose of the designation is to protect the waterfront as a resource for water-dependent industrial use. The reason for that is because this land just offshore is a 40-foot deep shipping channel, and we wanted to make sure that the land was reserved for water-dependent uses so as not to squander that resource of the deep water channel. The comprehensive plan goes on in several sections to talk about this waterfront port area, specifically talking about it again and again as an area for water-dependent industrial businesses to take strategic advantage of the 40-foot deep channel, 40-foot deep water channel, that is. And you see strategy C here for objective W4 speaks about, again, water-related and water-enhanced uses. Also in objective W8, speaking about land use, once again, talking about the Narragansett Bay waterfront, which has areas where we promote mixed use. That would be up in sort of the Fox Point area, but specifically, as we see in strategy B, talking about the waterfront port section as an area for strengthening the port as a regional economic engine, and very importantly, limiting the area to water-dependent or other related uses, incompatible supporting uses. That land use section of the comprehensive plan and the future land use map ultimately get translated into zoning. And here you see the zoning map. Again, here's the parcel of land with the little yellow star, and you see that this is the W3 zone. Incidentally, across Allens Avenue to the west is the M2 heavy industrial zone where Narragansett Improvement is currently located with their main plant. In that area, you can have materials processing that's not water dependent, but to the east of Allens Avenue, any material processing that you have, according to zoning, has to be water dependent. Here's the purpose statement of the W3 zone. Once again, speaking to promoting maritime, industrial, and commercial uses, and protecting the waterfront as a resource for water-dependent industrial uses. This is the regulation that the applicant is seeking relief from. This is right up front in Article 12 where we talk about uses, and 1200B specifically says, in the W3 district, all permitted and special uses shall be part of a marine enterprise or dependent on access to the waterfront. And I just want to bring up language here about variances. You know this well, but I think it's important to put it into the record that 1902 4A, parroting the state law with respect to use variances, the evidence has to be put into the record to demonstrate that the subject land or structure cannot yield any beneficial use if it's required to conform to the provisions of the ordinance. We don't believe that to be the case here. You can see, once again, the location of the parcel in the W3 zone to the north and to the south. There are many parcels that do have piers and other access out to the deep water channel, and of course Proudport is built out to the channel. So we think that this parcel can be used for water-dependent uses. Here's a zoom in of the parcel. You can see the pile of asphalt. This image was taken relatively recently. And I just want to point out that back in the 70s and 80s, there did appear to be some kind of infrastructure that did connect this parcel to the water, just to demonstrate that it is possible, and in fact it has existed on this parcel in the past. That's the end of my testimony.
Thank you. Board members have any questions of Mr. Azar? Okay. I see we have a number of people here to testify or to ask questions or to be heard from. As you may or may not know, we have, I think, more than 40 letters objecting to the proposal. The hour is late, we've been here a bit. I do want to have the opportunity to listen to you, but I would ask that please you try to not repeat that which others say. We understand, and I want to hear from you, but I don't want to hear the same thing 15 times. I don't think you do either. So with that being said, if someone would like to come forward and testify, please raise your hand. You'll be noted, and you'll go to the microphone up front.
Mr. Chair, I can take folks off the sign-in sheet.
Okay, very well, thanks.
The first name is Jacqueline Goldman. For anybody testifying both in person or via Zoom, if you could state your name clearly and spell it if the stenographer asks, and your address, please.
If I could state one thing up front, having reviewed all of the letters that have come in, many of them refer to the city's new Climate Justice Act. That is a separate act, and it is not yet included in the comprehensive plan or the zoning ordinance, and it therefore doesn't apply to zoning. I think that if you've reviewed these and have listened for long enough, you understand that the board has specific criteria that they apply in granting or denying a variance. This is a use variance, and it has specific criteria. We fully appreciate, and myself having worked on the climate justice plan, understand its importance. And eventually it will be incorporated into the comprehensive plan in some way, but it is not now. So if you are going to stand up and say, and testify with respect to that, we appreciate it very much, but it's not relevant to the board's decision. And I don't want to take your time and impose on you. Thank you.
My name is Jacqueline Goldman, and I live at 9 Samoset Avenue in Providence.
Can you raise your right hand, please? Just swear to tell the truth, the whole truth, and nothing but the truth.
I absolutely do.
Thank you.
Spell your first name, please.
Spell it, Jacqueline, Jacqueline, and then last name is Goldman, Goldman. And I'm not going to talk very long. I submitted a letter, and also I don't plan to be any sort of expert on zoning. This stuff is frankly very complicated, but also very important. I think that what we can see from, sort of the testimony that's going on is that there's been sort of like illegal use of the space that's led to a lot of pollution. And, they might kind of say that this is a green way to address the concrete recycling, but we know that this industry, as well as others in the Port of Providence, do a lot to actually harm the communities in their area. And especially if, they're not applying for the right kind of zoning ordinance, that this really should not be granted, as it seems as though both sort of the work on the back end is not correct and not in line with how they're supposed to be applying for zoning ordinances, but also causes a lot of harm to the community. And, this is a low-income community of color. We know that this leads to increases in asthma rates. I'm an epidemiologist by trade, and we know that, certainly there's a lot of asthma that happens in Providence, but it's even worse in that area. And so for many of those reasons, like, this ordinance should not be granted, both because it seems faulty in the way that it's like applying sort of in the legalistic ways, but also the harm that is being done in the communities. And that's all I want to say, because I know there's a lot of other folks that know a lot more than I do. So thank you so much.
Thank you for your time.
Next on the list is Gonzalo Cuervo.
Good evening. My name is Gonzalo Cuervo.
Sir, spell both names.
Gonzalo, last name Cuervo.
Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
I live at 328 Mount Pleasant Avenue, and I also own a home in Washington Park, which is about 1.5 miles from this site. And I'm going to be very quick. I think it's been made very clear that this use of this piece of land is not water dependent at all. And I think that this news that the piece of land is being sold, I think granting relief with this variance, the impact of this will far outlive the current use of that land and will open up a can of worms, and I think that would be terrible. And therefore I am in opposition to granting the variance. Thank you very much.
Thank you.
Andrew Saul.
Hi, Andrew Saul, S-A-A-L. Thank you for your patience.
What are you preparing to show us, Mr. Saul?
A different view of a common exhibit.
So you have to be sworn in?
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Carol, do you have name and...
All set, thank you.
Good
Mr.
evening.
Saul, do you have a copy of that you can provide? Because if you're showing it, it should be entered as an exhibit.
I would be glad if the chairman allows us as an exhibit to donate it to the planning and zoning.
Thank you very much.
Can you afford phone core? Good evening, Mr. Chairman and members of the Planning and Zoning Committee. My name is Dr. Andrew Saul. I'm a family physician and serve as the Chief Medical Officer of the Providence Community Health Centers. And I wanted to give you something you don't hear often, which is thank you. It was this committee that allowed us to shut down Warren Way at the height of the COVID pandemic and turn that into a drive-through, walk-through test site for COVID. So for 6 months, we shut down Warren Way. Thanks, it worked. And now we figured out ways to do other testing. But I wanted to show you what's in that blue box, which is right there next to the proposed zone. I speak tonight as a person who abuts the property within 200 feet. And I'm speaking on behalf of 600 employees of the Providence Community Health Center, serving 60,000 patients with 10 clinics across the city. But this evening I want to point out the blue box, that is the Chaffey Health Center. It's been there for about 20 years now. The Chaffey Health Center is the medical home of 8,000 men, women, and children. We have 2,500 children under the age of 18, and we welcome about 200 newborns every year. As others have mentioned, Washington Park, South Providence have very high rates of asthma, and the Chaffey Health Center is where those communities go to get their health care. And in fact, the bus stop is right there on the edge of the circle. Tonight, when I left my office to come down here, our 73-year-old secretary was standing at the bus stop to go home, adjacent to the asphalt and bituminous pile, if I said that correctly. So at Chaffey Health Center, over 400 patients have a diagnosis of asthma. You don't have to take my word for it. The physicians at Hasbro and the Public Health Department help us track where the children live and where they breathe. And in the last 12 months, our clinic on the east side of Providence had 8 children admitted for asthma to the hospital. Our clinic at Capitol Hill, right off I-95, had 12 children admitted for asthma. Our clinic in Olneyville had an amazing 20 children admitted for asthma. But the clinic serving Washington Park and South Providence had 39 children admitted for asthma. And many of those people do call the Chaffey Health Center their medical home. And it is exactly 225 feet from this. Tonight I'm speaking on behalf of the building right on Allens Avenue within the 200-foot abutment zone. We have 30 employees in there. But out back in that clinic, we have 10 physicians, 2 nurse practitioners, 2 behavioralists, and another 30 employees. That is the medical home for South Providence. But as an abutting neighbor within 200 feet, we do have 30 people right there in that office. and another 30 people in the building behind it. And throughout the pandemic, we've had to ramp up the HVAC units to get better air exchange in those buildings, 10 per hour. And though each HVAC unit now has MERV 7 high-density filters, the best you can buy for a building, realistically, the air intake into those buildings is essentially unfiltered. And more fresh air exchanges may have reduced COVID transmission in the offices, but they've increased the staff complaints about industrial odors. When they grind, I hear the complaints. The smell, the odors, the burning eyes. Now, just to say it obviously, recycling is a grand term, but we're talking about grinding up concrete and asphalt, and there are petrochemicals in there, and those are the odors. And for the last 2+ years, we have dealt with this on a very, very regular basis, and it has had some highly visible effects downwind. On August 26, 2019, a smelly white shroud left a tar-like residue on the vehicles belonging to our employees and the patients of the health center. The residue was described as sticky, gritty, oily, smelly tar. If the chairman wants, I have a stack of emails from our employees that were going on that day to enter as an exhibit. At the end, nearly 50 staff discovered their vehicles were covered with a tarry substance that could not be removed by conventional washing. By the following day, our facilities manager had contacted the responsible parties and the asphalt grinding ceased. So we do want to thank Mr. Dustin Everson and the Narragansett Improvement Company for rapidly taking responsibility for the environmental mishap and agreeing to have some 40 vehicles cleaned with a solvent and then power washed to remove this from the vehicles. And while most people were thankful that the harmful soot could be washed off with a solvent, more people kept asking the more profound question, which was, oh my God, did we breathe the same cloud? Oh my goodness, are these odors the same chemicals? And the odors have been ongoing even though the cloud stopped when this grinding stopped. The answer, sadly, is yes. Yes, we did breathe that same air, and no, there is no solvent I can use to clean anyone's lungs. And no, we can't just install better HVAC filters and compensate just to offset our neighbors' grinding activities. So on behalf of the 60 employees who abut this facility and the 8,000 men, women, and children who receive medical care only a few hundred feet away, I urge you to vote no on this variance. Thank you.
Thank you. You leave the material as well, we'll enter that as an exhibit.
Thank you. And you're welcome to a nice piece of home court. And in the future, remember there's a health campus right there in the middle of this zone. And, you know, thank you for your help doing the COVID testing, but we still got to keep people healthy.
Next on the list is Linda Perry.
Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Introduce yourself to the stenographer, please.
My name is Linda Perry, and I'm a resident of Washington Park. I'm a long-time resident, as you know. I don't want to repeat anything, but I took some notes. First of all, there's no guarantee that this land has been sold. So their argument I find somewhat ridiculous. That's my personal opinion, it's not my legal opinion. However, that pile has been there for 3 years, at least. It appeared 3 years ago, and I commented to the then Councilman Aponte and Director of DPW, Bill Bombard, what is that pile? And how long is it going to be there? And they said, oh, well, it's road waste. When we dig up a road, we process it and it gets reused. And well, how long is it going to be there? A year. Fast forward 3 years, a small pile, another small pile, a larger pile, right, getting closer to the water. Complaints to DEM, EPA, finally to the right person. And I complained to Chris Hunter, who is their lobbyist, gatekeeper. This doesn't belong on that site, which is grass, which is green grass. and it's going right into the water, okay? But irregardless of the environmental issues, it doesn't contribute to the health, safety, and welfare of our community, and that's what you're here to protect, the health, safety, and welfare of the community. And I urge you not to give them a zoning variance on the fact that it doesn't comply with the use. It's in W3, it's supposed to be a waterborne industry. There's a million other things that that land could house. Wind turbines, you know, for one thing, something green. It doesn't provide any jobs, it just provides pollution. And I hear it, I smell it, I am affected by it. The smell goes downwind, especially when they process it. I mean, it used to be just a pile, and now it's the equipment, the long equipment, and it's just grinding. And the smell, you could smell it for a mile away. And ignorance of the law is no defense. So they come to you and they say, well, we didn't know what we were doing. And I've been told that on a traffic stop. Ignorance of the law is no defense. It is your responsibility to know what you're getting into. And this use of this land here that they're trying to, I think, bamboozle us here with is not a smart way to grow the economy or the ecology of Allen's Avenue. It is detriment to the health, safety, and welfare of everyone that lives there, as Mr. Saul has just told you. And that's all I have to say. I ask you not to allow this variance. I don't want to take up all your time, but there is a long history of the pollution there and the non-compliance. And I am grateful that it got to the point where it came to this committee, that you have to make a decision. Thank you.
Thank you very much.
Next is Devin Pincus. I know that some of you have written your addresses down, but I'd like to remind you just to state your address when you come to the microphone. Thank you.
Okay, spell the name, spell it.
Devin Pincus, DEVON PINKUS, and I'm a Providence resident at 125 Parade Street.
Raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please begin.
So, I stand strongly in opposition to this application for land use variance. I'm grateful for all the folks here who have testified and brought their knowledge and expertise and lived experience to this space, and the folks who will come after as well. I don't want to take up time repeating anything, but I do just wanted to draw attention to a couple specific things from the actual application that Narragansett Improvement Company submitted for the variance. Throughout their application, in response to multiple questions, they kept saying over and over that there would be no greater financial gain to them by receiving this variance. And yet, in Appendix A at the end, they state that if they don't get this variance, it will reduce their ability to compete with surrounding businesses and will jeopardize their business. And we heard them say in their testimony here, over and over, they emphasized the financial hardship that would be brought upon them if they did not receive this variance. So I think the game that they were trying to play was to say that they will not necessarily receive additional profits than that they will already receive, but I would submit that not being able to function as a business without the use of this land, we're using this land and thus being able to continue to function is in fact a financial gain and is their end goal of this variance. So I think they're trying to play both sides and say that it's not about the money, but then on the other hand, they continue to emphasize over and over that it is in fact about the money for them, about their profits, and about their ability to continue to function as a business. Secondly, they have emphasized tonight, as well as on their application, that the use of this land is substantially similar to surrounding properties. That was on page 8 in response to the question or statement number 6. They said that attempted to justify their application for this variance by stating that the use is similar to adjacent properties. And I would submit that just because other people are doing abusive and illegal things that are resulting in a detriment to the health and well-being of a neighborhood, that does not justify someone else doing that thing as well. And furthermore, they have already been doing this thing for 3 years. And I think a lot of their testimony was predicated on the fact they tried to play that, you know, we're actually doing a good thing for the environment, but they've been operating illegally for 3 years. They tried to say they didn't know, but I don't think that that is true, as others have pointed out. So I think I will leave it at that. I appreciate your time, and I appreciate the others who have testified as well.
Thank you.
Yes.
Nina Wolf Landau.
Hi, thank you for your time. My name is Nina, N-I-N-A, Wolf, W-O-L-F-F, space, no hyphen, Landau, L-A-N-D-A-U. And I live at 903 Providence Place in Providence.
Nina, would you raise your right hand, please? Do you
Yes.
swear to tell the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you.
I will keep this short, and I want to echo a lot of the other comments that have been made tonight. I am submitting comments in opposition to this use variance application, and I also submitted a letter and don't want to be repetitive. I just want to say that, as we've heard, there have been years of illegal use, and now Narragansett Improvement Company is attempting to rectify that, which is part of a pattern of companies and their illegal and damaging behavior being grandfathered in and particularly impacting the neighborhoods in the Port of Providence. And as Dr. Saul and others have mentioned, there have been years of reports around noxious fumes and burning eyes and throats and day-to-day impacts on the people that live around the port. I just want to also add, as has been discussed extensively, this is not a water-dependent use, and as everyone has noted, granting this variance is a permanent change with no guarantees about future uses on this piece of land. So I just want to urge the zoning board to reject this application for use variance and protect the community's health, safety, and wellness, and consider all of the other comments submitted tonight. Thank you.
Thank you.
We're going to move to our Zoom attendee list of raised hands. First is Sandy Khai. That person has lowered their hand. We're going to go to Samuel Bell.
Hello? Can you hear me?
Yes.
We can, yes.
Thank you so much to the members of this board. I'm here to testify in opposition to this proposed use variance. My name is Sam Bell.
Thank you. Would you
At
raise your right hand?
212,
Please.
absolutely.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you so much. Please continue.
Thank you so much. I live at 212 Gray Street in Providence, and I'm very interested in this particular subject because I'm introducing legislation in the Senate relating to the way in which non-conforming uses are established as legal. And one of the things I'm very concerned about is the conditions currently under the standards that make it very difficult for housing units that have been non-conforming for a long time to become established as legal. But when we're dealing with non-housing uses, we have to deal with the very strong conditions under the current law under which this kind of legalization by variance may go forwards. And I think that it's very clear that the legal standard here does not allow this sort of legalization by a variance. And it's important to me because I think it's important that these standards be applied towards polluting uses as well as towards housing uses where I believe they create a detrimental effect on our housing supply. The standards, as Mr. Azar referred to, that are laid out in Rhode Island law, do require that in granting a use variance, the land cannot yield any beneficial use if it is required to conform to the provisions of the zoning ordinance, and I think that that standard is very clearly not met. It also clarifies in reference to the arguments brought forward about neighboring parcels that non-conforming use of neighboring land or structures in the same district and permitted use of lands or structures in an adjacent district shall not be considered in granting a use variance. And I think that that's really crucial. But also it lays out additional standards. And these standards are overwhelmingly just not met in this particular case. It requires that evidence be entered to the satisfaction of the board that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area. And I think a lot of the arguments brought forward do relate to the general characteristics of the surrounding area. But it also requires that it does not result primarily from the desire of the applicant to realize greater financial gain. Again, a standard I just believe is very clearly not met in this particular case, particularly when we think about the conditions around the possible sale. And, you know, I think that there's also a broader standard around impairing the intent or purpose of the zoning ordinance and comprehensive plan. Now, I know that arguments were brought forward about how a city ordinance does not necessarily meet the standard of being the zoning ordinance and the comprehensive plan on which the ordinance is based. But I do think that some of the ordinances passed by the city can have some relevance in allowing us to interpret the intent. And so I think that I would hope that we include any written testimony in the light any written testimony referring to a particular ordinance in the light that that ordinance may inform our understanding of some of the intent around these particular matters. And finally, of course, there is the standard that the relief to be granted is the least relief necessary. Now here, I just think it's very clear that there are alternate conforming uses of this parcel, and that standard is very clearly not met. So I would strongly urge this board to reject this proposal. I think it is crucially important that we fairly apply these standards, which are used routinely against housing uses and other uses that do, I believe, have a beneficial effect for our community, and I believe used to a detrimental way. That these standards, I believe, really must be applied equally in addressing heavily polluting uses. You know, pollution is the purpose, the reason for zoning is to prevent pollution too close to residential neighborhoods. And I just think this is a very classic case of the purpose of zoning and a classic case of where a variance is not either in the public interest or within the legal standards authorized by the Rhode Island general laws. So again, I really appreciate all the work that this board is doing to vet this case, and I would politely request that the board reject this proposed variance.
Thank you, Mr. Bell.
Thank you.
Mr. Garrett?
Hello. Am I on yet?
You are.
You are. Please state your name and where you live, sir.
My name is Greg Garrett, Gregerritt. I live at 37 6th Street in Providence.
Mr. Garrett, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please begin.
zoning, one of the key reasons for zoning is to protect the public health and safety. It's clear that no one should be receiving a variance if what they're doing harms the public health and safety. And it's clear from Dr. Sal's testimony that the work going on there on this site now harms the public health and safety. Narragansett Improvement is a long-standing business. They have been, I have lived in Providence for 25 years. They have been there and were there many years before I moved here, because they've been there the whole 25 years I've been. They've been in the business of recycling concrete for a long time. That they have used this site for 3 years without permission. But they were in the business for so long doing this. Where were they doing this before? Why did they need this particular site other than it's close to them? But they were doing the same business without having to use this site. The fact that it doesn't fit as a waterfront use, the fact that, you know, they have a contract with Provport, but we have to question about how well Provport is actually managing and thinking about the public health and safety. I strongly urge you to deny this because this is such a serious threat to the public health and safety and should be stopped immediately. Thank you.
Thank you.
Mr. Chair, we're going to go to the next person on Zoom, and then there are a few more people in the audience that will take.
Okay.
David, can you hear us? Mr. Belize?
Hello, good evening. Yes, good evening. My name is David Belize.
Spell something.
Can you spell your name and state where you live, sir?
David Belize, B-E-L-I-Z. I'm a resident of Providence.
Your address, sir?
I live at 49 Mary Street in Providence.
Name of the street again, please, sir?
The stenographer.
Marietta.
Marietta.
Yeah, thank you.
Mr. Belize, would you raise your right hand, please? You swear to tell the truth, the whole truth, and nothing but the truth?
Always.
Thank you. Please begin.
Good evening, everyone. My name is David Belize. I am the Environmental Justice Chair of the Sierra Club in Rhode Island. And we support environmental justice campaigns and in the whole state of Rhode Island. We are very concerned about granting a variance to any company that will continue to pollute a residential community, a community that, as we have heard, is disproportionately affected by environmental hazards. As the doctor mentioned, and as many other people have mentioned, that community has some of the highest rates of asthma in the country, as the Department of Health in Rhode Island has also confirmed. It is not accidental also, but this community is predominantly of color and of low income. We cannot continue to ignore the damage that environmental hazards have on this community and the people that live in it. We have talked for too long and not taken enough action. And we need to do what is right. We need to do what is just. And in this case, it means not granting this variance, not only for the people and the health of that community, but because it doesn't meet the qualifications of a water-dependent usage. So as this, representing my organization and our members all over the state and our members in campaigns in Providence, I ask you to please deny this variance. Thank you.
Thank you.
Councilman Gonsalves?
everyone. Good evening. Thank you for allowing me to speak on this matter and to provide testimony tonight. And thank you to the members of the Zoning Board for all that you do. My name is Councilman John Gonsalves, and I represent Fox Point, Wayland, College Hill, the Jewelry District in downtown. And I live at 385 Ive Street in Providence, Rhode Island, 02906. You've heard directly from...
Raise your right hand, Councilman, please.
Sure.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
So you've heard directly from Linda Perry, the president of the Washington Park Neighborhood Association, and several other folks this evening. And as you've heard, this is a community that has been disproportionately impacted by the climate crisis, and as you heard, has the 9th highest prevalence of asthma in the country. So when you make this decision tonight, I want you to think about your children and want you to think about your neighborhoods and your backyards and ask yourselves if this is something that you would want in your community. On the basis of legality, this does not meet the standard for use variant. They would have to demonstrate that it would be water dependent, and they have clearly not showed that, and this should not be allowed to move forward because, as you all know, this isn't water dependent. You've heard that directly from Bob Azar of the city, and this applicant has also been in outstanding violations of our zoning ordinance. The council, in fact, unanimously voted to amend the zoning ordinance to prevent these specific kinds of facilities from impacting the neighborhood in an adverse way. And the zoning ordinance should, quote, prioritize the waterfront as a resource for water-dependent industrial uses and facilitate renewed use of the vital waterfront. So with that being said, on the basis of legality, we do urge you to respectfully deny this variance request, and we also ask that you do that on behalf of the residents in this neighborhood, the children who will be adversely impacted, and the people in this community who will be adversely impacted by this proposal. So thank you very much for your time this evening, and I appreciate the opportunity to speak.
Thank you, Councilman.
Mr. Chair, we have 8 more attendees on Zoom that have their hands raised, and 1 in person, Senator Mack.
Hi.
Hello.
Tiara Mack, Tiara-M-A-C-K.
Where do you live?
Oh, 179 Camp Street, apartment 3.
Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
I won't repeat all the things that have been said, but I think it is without a doubt one of the themes of black and brown neighborhoods becoming dumping grounds for heavy polluters. And this is another example of an industry that has tried to prey on a predominantly black and brown and low-income community and get away with it. The fact that they were illegally occupying this space for years is an indication that they were not expecting a community to organize, get involved, and to fight back against this, to fight back against one of the things that is literally deteriorating the health of a community. I have gotten several emails. I am the senator in this area. I get many emails, many concerns, and one of the top issues that folks talk to me about in this area is the industry that's happening in the Port of Providence that is leading to higher rates of asthma than anywhere else in our state, some of the highest asthma rates in our country. And this trickles down to more days that young people are missing out of school, more times that parents have to take out of their work schedule, more costs for emergency health care. Oftentimes, these families don't have access to quality medical care. And preventative measures like inhalers, etc. And so they rely on emergency medicine, especially when they have asthma attacks for their young children, leading to many days in in the emergency room, many days missed from school, and exorbitant costs because emergency medicine is a significant burden on these families. So this is not just about protecting the health of this community. This is also about prioritizing the education, the finances, and the livelihood of this community moving forward, and something that this community and my community has been working towards. And I'm glad that there are folks who are organized around this issue and ensuring that industries like this do not continue to prey on communities just because they are already in the sight of many big polluters. Thank you.
Thank you.
Oh, we have Mr. Moore? Oh, I'm sorry. Give me one moment. We have Ms. Rachel Newman Green, and Mr. Moore, I will get you back up. Thank you.
Good evening, can you hear me?
Yes.
I'm Rachel Green. I live at 125 Peyton Street in Providence.
Ms. Green, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please begin.
Good evening. I'm speaking as a resident of Washington Park and as the mother of 2 children who spend all day, every day in smelling distance of Narragansett Improvement, since both our home and their school are in the south side neighborhoods nearby. I'm very encouraged by Mr. Resnick's testimony that the property is soon to be sold, and I sincerely hope that the existing harmful and non-compliant activities are not grandfathered and continued by the next owner. I'm excited to hear that the facility in question may vacate the site in the next 10 months, and I encourage the board to assist Narragansett Improvement in expediting the wind down that Mr. Resnick described. I also want to thank Dr. Saul for speaking on behalf of his employees for the experience I've shared as a neighborhood resident. I've called DEM numerous times over the past few years to alert them to the odors emitting from Narragansett Improvement's activities on Allen's Ave. Our home is about 1.5 miles from the site, and the unmistakable strong smell of asphalt reaches us several days a week, most weeks. There are days when it feels like the inside of my nostrils are burning from the odors. There have been summer nights when I've been woken up in the middle of the night to close all the windows because the hot summer air inside the house is preferable to the strong asphalt smell coming in from outside. We're fortunate that our family doesn't suffer from asthma or so many of the other health issues that make this situation far more threatening to many of my neighbors. The improper use of the Narragansett Improvement site contributes to my community having among the highest asthma rates in the state, and to our state having among the highest asthma rates in the country. I'm also fortunate that I understand these systems well enough to know that there's someone to call or a meeting like this to come to stand up for the health of my family and community. That isn't the case for many of my neighbors who are new to this country, who don't speak English as a first language, who have been historically denied access to decision-making processes like these, or who don't know, like I do, that a zoning code exists that, if enforced, can help protect our health and safety. I'm here today to ask you to deny this variance to enforce the purpose of the zoning code in protecting health and safety, and to enforce the specific prohibition against development of dumps, which is the purpose this site will continue to serve if this variance is approved. The continued use of this site as a disallowed dump jeopardizes the well-being of our community. This non-waterfront dependent use prevents the valuable port area from being activated for purposes that are in the better interest of the health, economy, and environment of our neighborhood, our city, and our state. Thank you.
Thank you. Next.
Mr. Moore?
Yes, my name is Tim Moore. I'm a lawyer with an office at 50 South Main Street. I'm here on behalf of Linda Perry and the Washington Park Association. They have expressed the law so clearly.
Mr. Moore, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Ms. Perry and other witnesses have described the law so clearly. I don't feel I need to add much, but I do feel that it is very encouraging to have Department of Planning oppose this. I'm citing the comprehensive plan, but one notices in the comprehensive plan there is no mention of protecting the residential neighborhood adjacent to the waterfront district. the comprehensive plan definitely needs to be amended. I represented Pat Conley when he made an aborted effort to try to change the Port of Providence from an industrial wasteland that damaged the neighbors into a place where you might have tourism and boats. He had a cruise line came in. He renovated a building. He fought Sims Metal and successfully won a lawsuit. But Sims has grown and expanded. Sprague Energy Salt Pile has now occupied the land right up next to Mr. Connolly's former building. The city really needs to do much more to change the Port of Providence into a place that people can use and which does not harm the neighbors around it. Thank you very much.
Thank you.
Andrew Poyant?
Mr. Chair, I was going to suggest that if there's anything new to be said by people, it's appropriate, but the hour is getting late and our regulations provide that we're not going to go beyond 9 o'clock, so.
We have Mr. Poyant who, thank you for turning on your camera, was somehow automatically promoted to panelist, but also only 3 more folks with their hands raised. Mr.
Okay, that's
Right.
great.
That'll be the last 4. Could you introduce yourself, sir?
Hi, my name is Andrew Poyant, A-N-D-R-E-W. Last name is P-O-Y-A-N-T. I live at 11 Trinidad Street, and I swear to tell the truth.
Will you raise your right hand, please?
Do
you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you for doing that again.
I'll try to minimize what I was going to say since a lot of people already said things. I'm an environmental scientist, and I just want to note that it is the onus of the owner and the business to make sure that they're in compliance with regulations and ordinances. And they clearly stated that they did not obtain a zoning certificate, and they did not seek consultation with the zoning board or planning board on this prior to starting their operation. Just a quick search on the Rhode Island Department of Environmental Management's website noted that they are the Narragansett Improvement Company, specifically at this location, is one of the top emitters in Providence for particulate matter, nitrogen oxides, and sulfur dioxide, all of which are extremely harmful to the lungs and the respiratory system. So as Dr. Saul discussed previously, the pollution that the Narragansett Improvement Company is emitting into the neighborhoods is detrimental to public health. And so I really hope that the zoning board denies this variance request, because this is not a water dependent use, as Mr. Azar has stated, and use your authority to have them clean up this operation as quickly as possible, because it is impacting the health of the residents of Washington Park and the south side of Providence. Thank you.
Thank you.
Michaela?
Hi, my name is Michaela McKay. First name M-Y-C-A-L-A, last name M-C-K-A-Y, and I live at 44 Grape Street.
In Providence?
Yes.
Thank you. Would you raise your right hand, please, Michaela? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please begin.
I'll try to keep this brief. I'm here to testify against this variance. The city and the community members surrounding this space, who are already overburdened with pollutants, can't afford to deal with this situation in the years to come. such as the health risks and that were brought up by community members and Dr. Saul, who spoke earlier. I believe that the Narragansett Improvement Co., a company that has been around for over 125 years, has options for where they can conduct this business or the connections to refer it to someone else. The cost to them feels as though it is the cost of making questionable business decisions at the risk of frontline communities. I urge the board to oppose this request. Thank you.
Thank you.
Go ahead.
Hi, good evening, board members. My name is Sandy Chai, SandyChai, and I live at 71 Arlington Avenue in Providence. The environmental consequences, oh, sorry, I raised my hand, yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
The environmental consequences of recycling asphalt are clear and lasting. I've had the pleasure of being a resident of the beautiful city of Providence for 18 years, an employee in Providence for 10 years, and a mother for 7 years. I worked at the Chaffey Health Center and parked across the street from this parcel of land, and I would argue that the children, the water, and the air quality of Providence deserve much better than this asphalt recycling plant. Thank you.
Thank you.
Mr. Chair, we have
Yes.
3 more hands.
Thought we said
They have,
three ago.
I did.
Hello?
Go ahead.
Hi, my name is Ruby Erickson. I live at 99 Butler Avenue in Providence.
Spell your last name, please, Ruby.
Erickson, E-R-I-C-K-S-O-N.
Swear to, raise your right hand, please, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I would just like to echo previous comments in opposition to granting use variance to the Narragansett Improvement Company on this parcel. And in my comment, I'm going to keep it brief. I just wish to re-highlight that even if Narragansett Co. chooses to leave and sell this parcel, if the board grants use variance to this specific parcel of land, it might end up under the jurisdiction of a business with even fewer misgivings about dumping toxic waste near our water and into our air. So I advocate instead that Narragansett Co. not be granted this use variance and be compelled to remove their waste from this area altogether. Thank you.
Thank you.
Thank you, Ruby.
May I ask those left, if you have something new to add, please do. If you don't, we've heard your comments from others.
Haley, go ahead.
Hello.
Hello, Haley.
Can you hear
Introduce
me?
yourself to the stenographer. Yes, we can.
Yes. Haley Bucky, B as in boy, U-C-K-E-Y. I live at 24 Evergreen Street in Providence.
Raise your right hand, Haley. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you.
You're welcome.
I just wanted to add that I actually have a loved one who works in a related industry, concrete and cement, in an industrial facility. So I understand that it is a dirty job and can be unhealthy, and it's also an essential job. However, I think that the fact that the company has already been doing questionable things, like trying to cut corners and asking for a variance that doesn't really seem applicable, it just concerns me for employee health of the company itself, as well as the residents in the area. So I guess I just want you to consider the health of everybody involved and the practices and history of the company. And I urge you to vote no on this variance. That's all.
Thank you for your time.
Hi, my name is Tracy Lee Allard.
I live at 109 Dean Avenue, Smithfield, Rhode Island. And I want to make sure that I swear in to.
Tracy, would you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Would you spell your first name, please?
Tracy.
Thank you.
Cool. I'm going to make it as quick as possible. I just would like to point out that according to the Department of Environmental Management, there is already nitrogen, phosphorus, fecal contaminants already in our Providence water. So I just would like to ask, like, why add more? Thank you for your time.
Thank you.
Mr. Chair, one last hand is raised.
How many?
One.
For now.
Ms. Gorelick, go ahead.
Hi, my name is Susan Shim Gorelick, Gorelick. I do not live in Providence, but I work in Washington Park neighborhood area, so I am very well aware of it. And I do not want to reiterate what everyone has said, but as an
Ms. Gorelick, may I just interrupt? You please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And I echo what's being said, but I also submitted my written testimony. But as a last person, I just want to, as an environmental chemist and economist, I concur what's being said, and I want to state that I would like this board oppose this application. And thank you for your hard work.
Thank you.
I have no other hands raised at this time. Read the report and recommendation, Mr. Chair. Even though we've heard from Mr. Azar.
No, I know. I'm just... Thank you, Mr. Resnick. You still there?
Yes, I am, Mr. Chairman.
Before I read the recommendation and close the hearing, is there anything further you'd like to add in light of what you've been hearing?
Yeah, I would just have one comment with respect to the variance running with the land, which I would most certainly agree with your solicitor and the other people that commented that is normally the case. But that's not the intent here, and it could be drafted in such a way that it solely existed during my client's tenancy on the property. There's no intent to, through subterfuge, create a use change that would exist in perpetuity and benefit a subsequent tenant or property owner. This is solely for the wind down that we expressed, and it could be limited in that way as a matter of law, but that's the only comment that I have. Thank you.
Okay, thank you.
Mr. Chair, Mr. Hunter has his hand raised as part of the presentation team. I don't know if he wishes to speak.
Yes, he does.
Yes, very briefly.
Extraordinarily briefly, since we haven't heard from you yet. Raise your right hand, Mr. Hunter. Swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Who are you, sir?
Yes, Chris Hunter, Christopher Hunter, 1765 Bicentennial Way, North Providence, Rhode Island. I'm the executive director of the Providence Working Waterfront Alliance, which is a coalition of most of the industrial and water-dependent terminals along Northern Allens Avenue. We spoke with all of our members, and they do not object to Narragansett Improvements variance request. It's similar to the variance request that was made, I believe, in 2014 on the same property, where we also testified in favor. We do believe in the importance of water dependency However, these projects, this parcel hadn't had a water dependent use in years, and we believe that these uses are in keeping with the industrial nature of the Allens Avenue corridor, and that's why we supported the one in 2014, and we also support this variance, this request.
Thank you. Okay. Let me read the recommendation from the Department of Planning and Development. The applicant is proposing to use the subject property for materials processing and storage of building materials. The subject lot is located under the Comprehensive Plan's future land use map designation of waterfront/port, whose purpose is to protect the waterfront as a resource for water-dependent industrial uses and use it to facilitate economic growth. The intent of the W3 zone is to promote maritime, industrial, and commercial uses and protect the waterfront as a resource for water-dependent uses. The comprehensive plan and zoning ordinance are consistent in defining the waterfront/port area in a W3 zone as areas intended for maritime water-dependent uses, which are vital to enhancing the economic vitality of the waterfront, which is a limited resource. Objective W4 of the comprehensive plan encourages intensive use of the waterfront for water-dependent businesses to take advantage of the deep water channel. The W3 zone permits a variety of water-dependent uses as evidenced by development around the waterfront. A hardship or lack of beneficial use is not apparent given the number of maritime uses that can be conducted on the site. Based on the plans provided, the proposed use does not conform to the zoning ordinance and comprehensive plan as it is not water-dependent. As a hardship isn't evident, the DPD sees no reason to grant the requested relief, and based on the foregoing discussion, the DPD recommends that the requested relief be denied. I guess we'll...
Shall I kind of bring you all
like
back full circle, please?
If you'd like to, quickly.
So, yes. So your task, as you know, but to remind you, is to apply the criteria in 1902B3 for a use variance. The burden is on the applicant, as you know, to present evidence to support each one of those criteria. If you find that there is no evidence to support any one of them, then that's a basis for denial because they have to meet all of the criteria. I would note that I just want to make a couple of notes. There was testimony about there being a housing court proceeding. For those of you who are not aware of how this works, once violations are issued, you can appeal them to the housing court, and you can ask to abate the violation. And the way to abate the violation is to come to this board and get a variance. And you have done that on other occasions for dimensional variances, I believe, primarily. But that's why he was referring to litigation. It's not litigation in Superior Court. He was referring to the pending litigation in Housing Court that led them to come here to request a use variance to cure the violations. So I hope that's helpful for you. You did not hear any expert testimony from the applicant. The testimony from the applicant was that of Mr. Everson. And then you have the DPD and you have all the public comment. Please apply the public comment only as they are relevant to the use variance criteria. And if you have any questions along the way, I am here to answer them as always. Sufficient? Anybody have any questions before you start? Do you want me to read the criteria, Mr. Chair?
I will do them one at a time as we discuss them. So, in granting a variance, the Zoning Board of Review shall require that evidence to the satisfaction of the following standards be entered into the record of the proceedings. First, that the hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structure and not to the general characteristics of the surrounding area, and is not due to a physical or economic disability of the applicant.
May I interrupt for 1 second? I forgot one thing. The only quote evidence you have about this being supported by a temporary use variance is the statement by Mr. Resnick that there's a sales agreement. You can give that such weight as you want. We don't know if there is or if there isn't. The counsel for Cumberland Farms was present, Mr. Chowdhury, I believe. And he did not testify, so you don't have his testimony.
We also
Or
don't.
he didn't confirm it.
We also don't know, even if it is accurate, that there's a purchase sale, we don't know if it's going to actually be consummated.
Well, that's correct. That's correct. And so that's another legal reason not to consider this as a temporary use variance, because you really don't have any way of knowing whether or not this is going to be consummated, and if so, when, or even that it exists. Okay, I'm sorry, Mr. Chair. I thought that was important.
So the first standard deals with unique characteristics of the land. We've all heard numerous use variances in the past, and there was no testimony that I heard that spoke to, in any way, shape, or form, the unique nature of this land. It's a large piece of land. It happens to sit in the waterfront district. It happens to be off Allen's Avenue. It's been owned by Cumberland Farms for a long time. I didn't hear anything unique about how it has to be used for this type of a purpose. It obviously had a use prior to this that was allowed, or it existed. But again, nothing that I heard evidence-wise that made this particular land unique for this specific use that the tenant is using it for. And in my mind, it's, again, echoing what Lisa said, it is incumbent upon the applicant to provide us with evidence to support a rationale for why there's something unique about this land, and I didn't hear anything at all. And certainly, there's no evidence of a physical or economic disability of the applicant. The second element is that the hardship is not the result of any prior action of the applicant and does not result primarily from the desire of the applicant to realize greater financial gain. I found it curious, and on the application itself, they did check off a box that said there was prior action that they took with this property. The prior action they took was to rent the property to Narragansett Improvement. So on the one hand, the prior action...
That being Cumberland Farms.
Cumberland Farms was the owner, rented it to Narragansett Improvements.
So they both took prior action.
So to me, you know, the prior action to cause this, and it echoed throughout their presentation, was they thought maybe they could do that which they did. They didn't care to do about what they did, but they've done it, and now therefore, X number of years later and after a violation, they're seeking their existence there as a rationale to support their ability to stay there. And to me, it doesn't satisfy the standard, and again, I didn't hear any evidence that it wasn't prior action. And again, as to primarily financial gain, they spoke to the additional costs and expenses that they would have to incur if they're forced to move product off the site, which again, it doesn't specifically speak to greater financial gain, but certainly there's more money to be made if they can continue to process versus having to shut the operation down and cart the product off the site. The next standard, that the granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of this ordinance or the comprehensive plan. We had testimony from an expert, Mr. Azar, who worked on our comprehensive plan and zoning ordinances, speaking directly to the fact that the purpose of the W3 zone is to encourage water-dependent uses, and continuation of a non-water dependent use flies in the face of the intent and purpose of the comprehensive plan, in my opinion. Next element, that the relief to be granted is the least relief necessary. Again, ordinarily when we hear least relief necessary, there's discussion of what other uses or businesses or attempts were made to use the property. They tried leasing it for, or selling it for many years and had no success. They had a variety of other businesses that couldn't use it. There was nothing else they could do, and this was the only thing they could do, maybe. And there was really no testimony as to what other plans they have done over the, well, they said, they did mention something about a zoning relief in 2014 that gave them some relief. I'm not certain what that was, but from 2014 till the date they decided to rent it to Narragansett Improvement, there was no discussion of what they did or didn't do during those intervening years, and certainly nothing from 17 forward as to what they've done to try to get someone to use the property that was a use that was compliant with the zoning ordinance.
To clarify on that use variance from 2014, they never took out a permit, a building permit, so that use variance is null and void. It was never perfected.
I'm not even speaking to the use variance, I'm just speaking to
I
trying to
understand.
hear what types of efforts they took over the intervening years to do something with the property, other than what they're doing now.
I just wanted to clarify one thing, Mr. Chair. Are we considering, and this may not be that important, but I'd just like to know for clarity's sake, are we considering the applicant to be Narragansett Improvement, Cumberland Farms, both?
Well, the owner of the property is Cumberland Farms.
Okay.
The applicant is...
Okay, because I think at times you've sort of implied one or the other, that sort of treated them interchangeably. I just wanted to understand.
All right.
I mean,
Mr. Chairman, this is Mike Resnick. I'm sorry to interject, but I want to make clear that I'm here on behalf of the applicant.
Okay, thank you.
Clearly, the owner is aware of the application, which have not been retained by the applicant. Thank you.
Thank you.
thanks.
And then the last element in discussion of a use variance is in granting the use variance, the subject land or structure cannot yield any beneficial use if it is required to conform to the provisions of this ordinance. Non-conforming use of neighboring land or structures in the same district and permitted use of lands or structures in an adjacent district are not considered in granting a use variance. And again, we've had use variances before us many times. A clause that sticks out to me that comes up often is that in considering a use variance, what is presented to us is evidence to show that there's no reasonable alternative that would allow the applicant to enjoy a legally permitted use of the property. I took a look at the use matrix. There were 20-odd, 30-odd uses permitted. There were another handful of special use permit uses permitted. There was no discussion as to what attempts were or not made to allow any of those to occur on the site. And certainly those are reasonable alternatives, and there was no discussion as to why those alternatives were not fleshed out. What also we're used to seeing is probative evidence of an economic hardship, financial statements, cost data, other information that's brought to us to say why this is the only thing we can do with the land. We can't make money any other way. We can't afford to do anything any other way. There's analysis as to why this has to be the only thing done. And again, there was no probative evidence of a hardship that was delivered to us. And I don't know, I don't want to say they failed on all fronts, but to me, they did very little to try to satisfy any of the elements of the use variance. But I'm curious to see, you've listened to all of this. What are your thoughts or views?
Mr. Chair, I agree with you wholeheartedly. I don't think that they've met any of the standards, and that, in my opinion, this variance application should be rejected summarily, denied. All of you have heard me speak many times in the past about the health and welfare of the community. We heard overwhelming testimony to that effect tonight. That aside, this application doesn't meet any of the standards as far as I'm concerned for a use variance. doesn't comply with the ordinances or the comprehensive plan.
Okay, thank you. Anyone else care to comment? Mr. Wolf?
Yeah, generally in agreement with Mr. Mitchell when you, Mr. Chair. I'm convinced they at least don't meet most of the most of the standards. I might quibble about whether they don't meet any of them, but I think since only one of them, since only not meeting one is sufficient to deny, I think that we clearly have a strong case for denial.
I agree with all my colleagues. I think the criteria that I think it meets the least, in my mind at least, is the financial gain. And yes, the financial gain area in Appendix A, they actually spell out that if they cannot continue to store and produce materials, they'll have to truck all these materials at a great cost. So it seems like it's a convenience because it's close to where their plant is located. I'm not sure if there's any processing happening where the variance is requested, but there doesn't seem to be anything. There absolutely seems to be a financial gain coming out of that application of the site.
Yeah.
So I'm also inclined to deny the variance.
Mr. Scott?
Mr. Chairman, the kind of the sticking point for me here is the prior action by the owner, where this situation is completely a product of that. So in that regard, it doesn't live up to the ordinance.
All right, thank you.
I am also inclined to agree with my colleagues here. There's an astounding lack of testimony and evidence that the applicant hasn't presented to us today, so.
Unless there's any other comment, someone care to make a motion?
I move to deny this use variance application.
Mr. Mitchell, you're an alternate. You can't make a motion.
Well, I'll make a motion. I'll channel Mr. Mitchell. I'll make a motion to deny the requested use variance.
Thank you both.
Motion from Mr. Wolf to deny the application for use variance. Is there a second to the motion?
Second.
Seconded by Mr. Struther. Any further discussion? I'll call the roll then. If you're in favor of the motion to deny the use variance, please indicate aye. If you want to vote to deny the motion.
Wait a minute.
Yeah.
Yes. What was the motion specifically?
Motion
I'm
is to
sorry.
deny.
Motion to deny. So if you agree with that, say aye.
If you disagree,
Say
then
nay.
Right. Just have to come up with the exact wording. Thank you. Disagree, say nay. Mr. Wolf?
Aye.
Mr. Struther?
Aye.
Ms. Maniotis?
Aye.
Ms. Rodriguez?
Aye.
I vote aye as well. Motion to deny carries 5-0. Thank you.
Thank you for your hard work tonight, members of the board, and long work.
Motion to adjourn?
Thank you.
Motion to adjourn from Mr. Struther,
Second.
seconded by Ms. Rodriguez. All those in favor, raise your hand to indicate aye.
Aye.
Motion
Ma'am,
carries.
ma'am, could you please come here, please?
Camera system
Okay.
going.
Oh.
Thank you all.
See, right there.
Because I can't.